Hey gang, welcome back to Talklyticaltv. It's your girl, Lytical J, and I'm back. Y'all already know from the thumbnail we're doing a YNWMelly update. We're about to jump in, but before we do, don't forget to subscribe if you haven't already, and give this video a thumbs up. That's how I'll know for sure you guys are liking the content.
Let me talk my shit for you, talk about it. Let me talk my shit for you.
Here's another twist. Alright, so YNW mom, I'm just gonna talk off the dome. I got my notes, but it's gonna be a little bit more off the dome on just based on what I've read and what I saw. So back in October, Jamie got called in to sit down for a deposition with a detective that I would say is well seasoned on the case. His name is Mark Moretti, if I'm not mistaken. Yes, his name is Mark Moretti, and he's out of the Miramar Police Department. He's been a detective that's been on this case since day one. For whatever reason, they believe Melly's mom, JamieKing, has something to do with some type of witness tampering within the case. They're not naming who this witness is, but that's what they believe. So this detective went ahead and obtained a search warrant for her phone and everything to do with her phone, social media, anything encrypted, anything that's been erased, cloud, everything with her cell phone. So apparently there must be someone, one of the witnesses in the case that's more than likely would be a witness that is not in favor of Melly. Meaning they wouldn't be on their side. They would be more on the prosecution side. So for whatever reason, if this is true, because this is all alleged, that she is stepping to one of the witnesses and saying things of such of, yo, don't, get missing. This could be Felicia Holmes, maybe her mom, we'll pay y'all off, don't show up, just keep dodging them, things like that, is, witness tampering. You don't have to try to scare a witness. You can try to bribe a witness, and it's the same thing. So it's something in that nature that they're alluding to. So the detective went ahead and proved to a judge that they believe that they have strong evidence that she is tampering with witnesses. So they were granted a search warrant to obtain her phone. I guess they guised it under the fact that she was coming in for a deposition in reference to the case, but maybe not alerting her that, hey, we're calling you in to sit down to talk about possibly charging you with witness tampering. If that was the case and it was really strong, then maybe they would have just went ahead and also obtained a warrant for her arrest. But that's not the way that it went. They only obtained a warrant to seize the phone. So I'm assuming from what I've read that they lured her down there, which she was smart. She went down there with a lawyer, and in the sit down in this interview room is when she and her attorney would find out that she's possibly being looked at about this witness tampering thing. And at that point, she was served with the search warrant to obtain her phone. Now, in a motion that I've read, which this motion spills it out clearly, or what Jamie's attorney would, from his perspective, what would have happened that day in that interview room when she was called down to sit down for said deposition. When they went in, she was served with the search warrant, and they said this detective got overly aggressive. When she was served with said warrant, she advised him that she would have to contact her employer to let him know that, if they were trying to contact her, that they wouldn't be able to get in contact with her because she would no longer have possession of her phone. Now, that could have just been a tactic for her to maybe quickly try to see if she can delete something, because now she would have been on to game. So if she know damn well that that's what she was doing, and there was stuff still lingering off in her phone, I mean, I don't know how far she would have gotten in deleting things and how much things would have been on her phone, but you never know. People panic and they try to do things. So maybe she well and all did need to call her employer. She is a nurse, so I can see that being very truthful, but you never know. Now, anyways, they said once, I guess, the phone was visible to him and she took it out to place this call to the employer, he snatched it out of her hand so hard that it bent her fingers back. And, still to this day, she has to go to physical therapy because of that. Now, from the date, they've had her phone over 30 days now. And this motion that her attorney put into the court is requesting that this detective return her property, and that it was illegally seized because of the way the search warrant was served, that it was served in the Broward County courthouse without a Broward County sheriff official presented in front of all of the parties. So I guess her attorney would be alluding that the search warrant wasn't it was obtained rightfully the right way, but it wasn't executed legally. So that's his grounds, and I guess we will have to wait to see what all that entails. I also noticed in that motion that he said something to the effect of that when they sat down for this sit down, that, of course, everything was on record and was being recorded. And on that recording, it was said that Jamie would obtain immunity from prosecution in regards to the whole allegedness of her, tampering with witnesses. Now, how could you straight away gain immunity if they just went ahead and still snatched up your phone from you? That means that they're looking for something to match up with what they already have or what a witness said, and they're looking to charge you, sis. So I want to know a little bit more about this said immunity. Like, how do you just get immunity straight off rip? Unless for sure you are really out here witness tampering, which wouldn't look good for this case at this point. I mean, it's just so many things that's happened with this case. It's like, wow. Every time I do coverage on this, it just blows my mind, the twists and turns that this case takes every time. Now, a little aside from that, as far as the appeal, I'm not sure if a lot of you guys know, most of you probably already know, that on November 9th, the appellate court came back and said that let me get my notes out for this, because this one, is not really deep, but I just want to make sure that I am accurate with what I'm saying. So on November 9th, the appellate court went ahead and granted in favor of the prosecution that they can go ahead and put the death penalty back on to the case. Pretty much it's back on the table. They can seek it. The initial reason it was off the table is because the judge in the lower case, which now I think is no longer the same judge, it would have been Andrew Siegel. from my last update, I think the judge has changed. Now I'm not sure if that is because he's probably on vacation or because of everything that happened with the whole appeal and him siding with Melly's attorneys to take the death penalty off the case. And now that the higher court, the appellate court, is now siding with the prosecutors and saying that yes, they did nothing wrong. They did file the motion to seek the death penalty in time, and they didn't do anything wrong. They actually did everything by the books, and this is why it can still stay on the table. So the higher court reinstated all of that. Now, people hear that and think that it's set in stone. It's not yet set in stone. Looking at the opinion of what you would call it, of the decision that was rendered back from the higher courts, it says that it's not a final deposition, and that if Melly's attorneys want to, they can file a motion for a rehearing. So what they would do is go through this decision from the higher court and see if there's any errors or anything that they do not agree with or that they would like to object, and then it would go back on to the calendar again for them to hear it all over again. So this process is not yet finito, but in some retrospects, the higher court is saying, by all rights, we're siding with prosecution. They did nothing wrong, and we can now go ahead and seek the death penalty. Now, let's talk about the Parkland teenage boy down in Florida. We want to talk about this a little bit because a lot of people would say, well, oh my God, he beat that. He got off of that. In all retrospects, to understanding that this is a process. The reason why, and I was like, wow, same courthouse, different judges, but same kind of crimes. Now, different amount of bodies, but from my understanding, with a capital case like this, when you go into the trial part of it, before you find the juries and stuff like that, the juries, I guess they get to vote on if they truly believe, from the nature of the crime and everything, of the legalities of the, how the guidelines on how you determine if one should get the death penalty. Then in that case, they voted unanimously to take, the jurors voted unanimously to take it off the table. And that's why he was able to beat it. He didn't beat it off of a technicality of, oh, well, the prosecutors didn't file the intent to seek it in a timely fashion, as opposed to taking it back to Melly. That was the error or the defense that his attorneys thought that they saw an error in the filing of that whole seeking the death penalty thing. It worked for a little bit until it got to the higher courts, and the higher court said they did not need to refile a new one because the initial one that they filed still stand. Now, if you've been following the case from the beginning of time, you would know that there was 2 different indictments in this case. Now, with the indictments, a crime is done, they bring up the charges against you, and with that, the prosecutors would have had to file a certain motion by a certain amount of time to say, hey, we're seeking the death penalty in this case, which they did. That was back in 2019, I believe. Now, in concurrent to 2022, for whatever reason, they needed to add aggravating factors to a new indictment. So with that, what Melly's lawyers were saying is that, okay, well, you guys went ahead and filed this new motion or this new indictment. Well, you need to also file another motion to seek the D penalty, which they already did. So this is what the higher court is saying. They did not need to do a second motion. The one that they did in the beginning stood and holds firm. So let's wait to see if Melly's attorneys are going to counteract with the motion, or if they see if they find any type of errors in this ruling. But yeah, this is where it's at. I do see a court date for December 3rd. I'm not sure if this court date it will be addressing the motion to return Jamie's phone, or the whole execution of that search warrant, and or if Melly's attorneys decide that they are not going to counteract the higher courts, then I think the next step is trial. Yeah, as far as my last video goes, I talked a little bit about a attorney by the name of Christian Shabanos, and lastly they were trying to block him. His attorneys were trying to block him from sitting down for a deposition to talk about the inside stuff that's going on within the jail, about how Melly's attorneys were trying to help him to escape, which is, you know, to me is a crap. Like, why would a professional lawyer firm, attorney firm, put their profession on the line for Melly? How far would he have gotten? That makes no sense. But this is truly a belief in their eyes that this was a plan and this was going to happen, and they have proof in this. They say they have proof allegedly. This stuff is playing out in the background. You wouldn't really see a lot of paperwork about what's internally going on, because when you're in jail and you do things inside of the jail, it plays out within. If your lawyers start contesting some of those things, then that's where you'll see them spill out a little bit in the motions that we see. But we don't really know exactly where that's at right now. But what I do know is the judge granted the motion to block Christian Shabanos from testifying in the case, saying that he doesn't have any information on what's going on with the allege of him trying to escape and everything about the pipe bombs and all the stuff that he had, and all the violations that were happening within the prison, but within the Broward County Jail. But all while Christian Shabanos gave an exclusive interview to Complex Magazine about him being forefront investigator with all this knowledge about, you know, the information and the evidence, which is what they have against him, to drum up these new things that they're saying that he's doing within, to say now that he has none of those knowledges and he shouldn't be required to sit down for said deposition. Anyways, jump down in my comments and let me know how you guys feel about this update. I think we're getting closer to some type of trial. I'm wondering if, you know, when they go into the trial, if they, because I know that they did like some type of jury selection already. So are they going to use the same people that they already picked, or would we have to do this whole pooling of jury again? And would they have to vote in, just like in the Parkland shooters case, if they would have to vote, you know, if they would get to keep the D penalty on the table or not going forward? Again, thanks for watching. Don't forget to like this video, comment, and subscribe with post notifications turned on. The gang, I'll see y'all in my next one.
Let me talk my shit before you talk about it. Let me talk my shit before you talk.